We have a suspect in black heading west. Sir, you're being detained as a robbery suspect. You have the right to a counsel. You understand?
Yes, I do.
You may make a phone call once we reach the police station. Please follow me.
So, sir, how was your day?
It was okay.
Sir, would you stop beating around the bush and tell me the truth?
That is the truth. Not lying. I'm
Yes.
telling the truth.
I don't believe you.
Orders in session. I plead not guilty.
On November 20th of 2016, Mr. Tran was found walking down Venice Street and matched the description of a robbery suspect who was wearing a black hoodie and heading west. The Crown would like to request for more time to gather reasonable evidence.
The court approves of your request. Court is adjourned until January 2nd, 2017. Mr. Tran, we are granting you bail. However, we have some conditions you must follow. One of the conditions we have is that you have a curfew till 7 p.m. and you must report to our officers weekly. Do you understand?
I do. Oh, sir.
Hi, Felix. What's wrong? I have allegations that you're stealing from stores.
I'm innocent.
Even if you're innocent, I can't have you here. I can't have
I
you
swear I'm
here in my
innocent.
office to get
I'm
your stuff out.
innocent.
You just gotta go now. I'll keep your stuff. I'll sell it if you need it.
Oh man, it's already December 17th. That stupid trial lost me my job. I should probably go apply for more jobs. Hello, miss. I'm here to apply for a job. I've seen your help wanted sign outside. Yes.
Under your criminal record, it says currently on probation. Can you tell me more about that?
Yeah, I have a trial on January 2nd. It's for robbery.
I don't think I can hire these. Sorry.
Can't get a job. Oh my gosh. What am I gonna do with my life? Can't get a job.
Hey, it's a message from my attorney. Mr. Tran, sorry to inform you of this, but unfortunately the Crown has requested for extension and your trial has been moved to March 11th. March 11th? That's 3 months from now. Can't get a job for 3 more months? That's insane.
Melo Gogliuta and Jose were charged with conspiracy to commit extortion against Peter Belmont. On November 12, 1983, Peter Belmont and his bodyguard, which was an undercover police officer, were visiting a tavern in Concord, Ontario. When they were about to leave, they were pursued by a car that was driven by Halsey, and the passenger was Askov. Halsey and Askov got out of that car to threaten Peter Belmont. But luckily for Peter Belmont, the area was under surveillance and the police were able to move in fast enough to arrest Halsey and Askov, and were detained in custody for nearly 6 months. On May 7, 1984, they were to be released on recognizance of $50,000. When the preliminary hearing commenced on July 4, 1985, it could not be completed because there was another preliminary hearing that was taking place that same day. As a result, the preliminary hearing would have to be completed until September 21st, 1985, which was about 10 months from the arrest. Furthermore, trial date was set to be available on October 5th, 1986, which was more than a year away and 2 years after the initial arrest. On October 25th, 1986, when it was apparent that the case simply could not be heard during that session, counsel of the appellant and the Crown appeared, and the case was put for trial to September 2nd, 1986.
The issues with the case R versus Askov are under Section 11. It states, anyone charged with the offense has a right to be tried within a reasonable time. The goal of this law is that first, the lawbreakers are brought to trial and dealt with according to the law. And second, that those on trial are treated fairly and justly. A quick trial has practical benefits, like since memories fade, witnesses may move, become ill, or in extreme cases, even die. In Askov's case, he had his preliminary hearing in July 1984, but could not be completed till September. The first available trial date was October 1985 and was delayed until September 1986, almost 2 years after his preliminary hearing. During these 2 years, Askov's Section 7 rights were also violated: the right to life, liberty, and security of a person.
When R.V. Askov proceeded to trial, the District Court Judge Justice Bowen found that a 34-month wait was excessive and that 2 years is too long for a case to proceed to trial once it has reached the District Court. He also said he found the delay attributable to the chronic shortage of institutional resources in the Judicial District of Appeal. With the trial court judge's decision, Askov was acquitted of all his charges. The Crown, displeased with this, appealed the case. The Court of Appeal concluded that Section 11B of Askov's rights was not infringed, as 1. There was no misconduct on part of the Crown, 2. There was no allegations or objections made to any of the adjournments, and 3. There was no actual evidence of any prejudice done to Askov himself. Unhappy with the Court of Appeal's decision, Askov reappealed the case to the Supreme Court of Canada. While reaching their decision, they reviewed cases such as Mills v. the Queen and R v. Brady. After reviewing these 2 cases, they found 4 factors that must be taken into consideration when dealing with a person's Section 11B violation. The first factor they took into consideration was the length of the delay. In Askov's case, it was an unreasonable amount of 2 years between the preliminary trial and the first actual trial. The second factor was the reason for the delay. In Askov's case, it was due to institutional shortcomings which could not have been overcome. The third factor was the waiver of time period. Although Askov made no objection, the trial judge also stated that his silence cannot be inferred as a waiver to his right to be tried within a reasonable bound of time, and the Supreme Court of Canada agreed with that. The last and fourth factor that the court took into consideration was any prejudice occurred to the accused in that delayed trial period. While Askov was on bail, he faced many prejudice, such as having a curfew and not being able to interact with his fellow members. The Supreme Court of Canada stayed with the trial judge's decision and struck down the Court of Appeals, as they found that a delay of 2 years was unreasonable and Askov could not be held responsible for that delay. He was acquitted of all his charges.
So, Humera, what could have happened to Felix if he was fired?
He could have objected when the judge set the adjournment and told his attorney that the delay was unreasonable. Know your rights. Okay.
No, it's not. You're laughing. That was you. I didn't smell it all.